Ripple versus SAC key factor delaying judge's final decision. The confrontation between Ripple and the SEC is being intensified by the day. Ripple is taking its fight against the Securities and Exchange Commission to a higher level by contesting the testimony of experts and expressing worries about the disclosure of financial data to the general public. Ripple contends that the Fox declaration is professional testimony that has major legal ramifications, while the Securities and Exchange Commission SEC has classified it as routine evidence. This is one of the sticking points. Ashley Prosper has emerged as a crucial figure in the ongoing struggle between Ripple Labs and the Securities and Exchange Commission. And her X updates have sparked passionate discussions among the audience. The only thing that is preventing Judge Torres from making his final decision, XR community now, the only thing that remains in the Ripple v. C case before Judge Torres can make her conclusion is for Judge Netburn to issue her ruling on whether or not Andrea Fox is a summary witness or an expert witness. That is the only thing I have to say. Because of it alone, another can of could be opened. Ashley Prosper is drawing attention to a specific aspect that is keeping Judge and Nelisa Torres from making the final verdict, even though the outcome is still unknown. After the Securities and Exchange Commission submitted its opposition brief to Ripple's omnibus sealing request, Prosper observed that the only thing that was preventing the judge from accepting Ripple's motion to exclude Andrea Fox's expert declaration was the decision that Magistrate Sarah Netburn made. What exactly is the Fox's predicament? During April, Ripple submitted a motion to exclude Fox's declaration, which the SEC used to justify its demands for remedies. Fox's declaration, according to Ripple's argument, constituted her an expert witness, which is something that ought to have been provided during the discovery phase of the remedies process. As a result of the fact that the declaration was not issued during the discovery process, Ripple requested that the judgment exclude the testimony. On the other hand, the Securities and Exchange Commission asserted that Fox was a summary witness who merely described the prior events to assist the judge in comprehending Ripple's financial records. A significant realization was brought to light by Prosper, which is that if Fox is regarded as an expert witness, it has the potential to raise a can of worms that might further prolong the case. On the other hand, Magistrate Netburn's decision-making process for minor motions normally takes approximately a month, which means that her decision might arrive at any time. However, if any of the parties submit an appeal to Netburn's ruling, the final verdict that Judge Torres would render could be postponed. The court will make a decision. Although Prosper believes it is doubtful, he is holding out hope that the court will disregard Fox's declaration if she is designated as an expert witness. Legal representatives that support XRP, Bill Morgan and Jeremy Hogan, agree with the statement that even if Fox is considered an expert, her testimony will be preserved, but Ripple will have the opportunity to challenge her. Fox's statement is extremely important for the ultimate verdict, and it may have an impact on the punishment that Ripple receives. As a result, it is quite probable that Judge Torres will wait for the decision that Magistrate Netburn makes before rendering her final verdict. After Magistrate Netburn decides on the Fox declaration, the subsequent filings are most likely going to be the final ones. Should the judge choose to disregard Fox's declaration, it may limit the alternatives available to the SEC in terms of advocating for particular fines. Ripple was accused of breaking securities laws through the sale of XRP by the Securities and Exchange Commission SEC in the latter half of the year 2020. An agreement was reached in July regarding the selling of XRP on exchanges, which was a partial success. Nevertheless, the disagreement on sales to institutions continues, which is prolonging the court struggle. In the ongoing legal dispute between Ripple and the Securities and Exchange Commission SEC, the chief legal officer of Ripple, Stuart Alderati, has expressed his strong disapproval of Gary Gensler, the chair of the SEC. In the meantime, Alderati's recent action against the chair of the SEC highlights the growing tensions that are occurring as the case moves forward. This action also highlights the high stakes that are involved for Ripple, as well as the cryptocurrency sector as a whole. Additionally, it is a reflection of the fact that cryptocurrency has become an essential component of the presidential election in the United States. Aiming at SEC Chair Gensler, Ripple's chief legal officer Stuart Alderati voiced his extreme disapproval of Gary Gensler, the chair of the Securities and Exchange Commission, on X. During his job, he accused Gensler had exceeded his power and turned into a political liability. Specifically, he stated that Gensler played his hand too aggressively. His perception was that crypto was a simple target. He took great pleasure in becoming the person that everyone admired and despised. He believed that he was exempt from the oversight of Congress. It is no longer there on the current political climate. He is a political liability. Importantly, the comment represents the mounting grievances that are being expressed within the community of cryptocurrency users. This comment, on the other hand, was a response to another post that brought attention to the unique political spotlight that is being placed on the SEC. Not only is it rare for a presidential contender to mention the chair of the Securities and Exchange Commission by name, but it is also unprecedented for a sitting president to threaten to veto legislation that is related to the SEC. A further degree of complexity has been added to the continuing legal dispute by the inclusion of this political dimension. The significance of the Ripple case extends beyond the persons directly involved in the case. As a point of reference, Uniswap has referred to the Ripple case in its legal battle with the SEC, specifically regarding the nature of airdrops. In the meantime, a lawyer who supports XRP named Bill Morgan made the following observation. Uniswap felt the need to argue that airdrops are not investment contracts. Airdrops must have been mentioned by the SEC in the notice that was issued to Wells. Morgan drew attention to the conflicting stances taken by the SEC, adding, "It is incomprehensible that some tokens that are distributed are inherently not securities, while other tokens that are sold are inherently securities. In all likelihood, that is due to the conditions of the sale." The broader implications of the Ripple case are highlighted by the fact that this judicial dispute took place together. To put it another way, the strategy that the SEC takes to regulating digital assets is currently being subjected to a great deal of scrutiny, and big players in the cryptocurrency industry are keenly monitoring the results. Ripple's petition to redact and seal some information was recently challenged by the Securities and Exchange Commission SEC, which ratcheted up the intensity of the ongoing court struggle. On May 21st, the Securities and Exchange Commission SEC contended that Ripple's request to withhold information about financial and securities sales from the general public was unconstitutional. In its most recent filing, the regulatory body asserted that the information that Ripple is attempting to conceal, which includes financial figures, sales data, and discounts to institutional investors, is essential for the decision-making process of the court. In addition, the Securities and Exchange Commission underlined that this information is essential for comprehending the fines and remedies for the case. It was contended by them that Ripple did not provide sufficient evidence to indicate how making this information public would result in significant harm. Additionally, the SEC observed that some of the material that Ripple wishes to conceal is either already accessible to the general public or has become obsolete. Johnny Dad, the information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making any decision about investments, we strongly advise conducting independent research and consulting with a knowledgeable professional.